Our next custody case is Feehan versus Superior Court, which is found on slide 26. This decision addresses the court's authority to grant temporary custody to an individual when parentage has not yet been determined. In this case, there's 4 people that I'll refer to by name, and I'll give you a little bit of information about their tangled relationship. We have Lauren Setto, Bobby Feehan, June Guide, and their minor child, who is referred to as LS in this decision. Now, the relationship of these people is as follows. Lauren Setto begins a romantic relationship with Bobby Feehan while she's pregnant with LS. At the same time, Setto is in a relationship and is a registered domestic partner with Jude Guide. Guide adopts LS after her birth, making Setto and Guide the legal parent of LS. Confused yet? In November of 2023, Setto ends her relationship with Feehan. And according to Feehan, Setto cut off all contact between himself and the child after the breakup. Feehan files a petition to determine a parental relationship with LS, even though he's not the bio dad. And in his declaration, he claims that from the time of LS's birth, he acted as a parent to LS. And he provides a lot of examples as to why the court should agree with him. He resided with LS and Setto until LS was 5 years old. He provided daily child care, such as bathing, dressing, sleep training, and potty training. Participated in the child's education, traveled with LS and Setto, attended special events such as preschool, graduation, birthdays, and holidays. And I think very importantly, LS refers to Feehan as one of her parents when talking to third parties. So Feehan argues that the court should determine, number one, that he's a parent to the child. Secondly, he says, while this is going on for the court to make that determination, I want temporary visitation. Well, of course, Setto and Guide oppose his request, explaining that they were each awarded 50% custody of LS as part of their divorce. They also claim that Feehan was not a parental figure, but instead a former romantic partner of Setto who occasionally helped with child care. At the hearing, the trial court denies Feehan's request for temporary visitation after concluding it does not find authority under the circumstances to order pendente lite custody and visitation. So it says, I don't see any law here, I can't do it. Feehan files a petition for writ of mandate, and the Court of Appeal finds that pursuant to Family Code sections 3022 and 3100, subsection A, trial courts have authority to enter temporary visitation orders in parentage proceedings if the requesting party has made a preliminary showing that they are a presumed parent and that the order is found to be in the best interest of the child. So accordingly, the Court of Appeal issues a writ of mandate commanding that the trial court vacate its order and hold a new hearing to reconsider Feehan's request. So I think that this is a very important case because it answers a question that many of us have had for years. This isn't the first time that a court has been confronted with this issue. And I've seen courts say, well, okay, I'm going to give you some visitation, but not that much because of the fact that we haven't determined parentage. But now we have a very strong legal decision here that says that it's appropriate. And so, put this one aside because I'm sure that we're going to see this a lot more. The Court of Appeal also, as you saw, said, look, you have to make a preliminary showing that you're the father, right? You've got to make a prima facie case. And I think Dad in this case did a really good job. So if we're handling one of these cases, this is what you do. You talk about all the involvement with the child. And then finally, if you're interested in reading this decision, the court does talk about how society has changed. And it's not uncommon now for there to be more than 2 parents in a family.